Hello, good morning. My name is Konrad Clifton, an organizer at SMIEO.
Good morning, everyone. My name is Willem, also an organizer at SMIEO Employers Organization.
It's very nice to have you all with us today. We've got the privilege of being able to do a presentation to you today through this webinar. The heading for the webinar is called Down Tools Managing Strikes, Lockouts, and the Fallout. We are going to start off by just running you through the procedure that we will be following in terms of the webinar, and we will be finishing off with Q&As. For the sake of everybody just being on the same page, we've put together a PowerPoint presentation. So I'm going to be sharing my screen with everybody. Just bear with me for a second. And I think that you should all be able to see my screen right now. And yes, we will be running through the PowerPoint presentation and dealing with various topics that relate to, well, the topic of strikes and lockouts. The way that we will be doing the presentation is I will be speaking about certain topics relative to this webinar. I will then hand over to my colleague, Willem, my fellow member, who will proceed with discussing other topics. So, yeah, I think probably the first question that we should be addressing in terms of the webinar is, why is it relevant now? So I know that many employers have recently come out of wage round negotiations. There's obviously always a possibility that a strike is something that can happen. Now, January is quite close by, and the financial year is also going to be a general period of time when there's a possibility for wage round negotiations to take place. So it's an opportune time to talk about it, as strikes is something, as well as lockouts, is something that needs to be planned for, and contingency plans need to be made for quite well in advance in relation to who it is for. So this presentation is aimed at anybody that is interested in strikes or lockouts. There is, however, going to be a specific emphasis on business owners, HR managers, and anybody who is, so to speak, at the front line of a strike or lockout, so that you are adequately equipped to be able to deal with it as it occurs. I always recommend that when a situation like this happens, that you get legal advice, as you'll note throughout the presentation that this is actually quite a complicated topic, but we're going to do our best to try to keep it as simple as possible and as conversational as possible, so that you understand some basic principles about it. Excuse me, I see that there's somebody that wants to be admitted. Okay, that person has been admitted. What we will cover is basically strikes and lockouts, and in relation to how a strike and lockout falls into South African law. We will also have a discussion about what constitutes an unprotected strike, or what actions you can take as an employer relating to unprotected strikes. The last thing that we will be covering is what we want you to leave with. So basically, I think it's important to note that there is no business in South Africa that is strike-proof. Strikes are a reality, as are lockouts, and this webinar is basically here to enable you to be able to adequately respond to a strike and lockout. And obviously, feel free to give us a call if something like that happens. I will now be moving over to the next slide, which is basically the running order of things. So I'm going to start off by discussing definitions with you, basically giving you an understanding of what constitutes a strike and a lockout. I will then be moving over to, where the legal parameters are of a strike and lockout. Is it allowed at all? The answer to that is, of course, yes. But there are specific legal parameters in which a strike and a lockout can occur. We will then move over to getting protected. This is where we discuss what processes have to be followed in order for a strike or lockout to be protected. We will then run you through some practical elements and some advice in relation to what you should be doing while a strike or a lockout is taking place, with specific emphasis on pay, replacement labor, otherwise known as scab labor, how to deal with pickets, and what the appropriate disciplinary processes available to you if something like that happens. I just wanted to emphasize that a strike or lockout does not automatically entail you the right to take disciplinary action, but there are instances when a strike and lockout can give rise to disciplinary action being followed. So I think it's important that I just mention that from the onset. But we will be discussing that with you in quite a lot of detail. We will then be moving over to unprotected strikes. You generally stay away from the word of illegal strikes. Unprotected strikes is a better phrasing of the word because it is still, so to speak, striking is a constitutional right, but that doesn't necessarily mean that you as a business owner are expected to be subjected or allow yourself to be subjected to strikes where the necessary due process haven't been followed. So unprotected strikes is quite a big topic. My colleague Willem will be discussing that in quite a lot of detail. We will then move over to discussing some recent case law. South African law, one of our sources of our legal system is case law, which means that the Labour Court deals with these sorts of issues relating to strikes and lockouts. It's actually quite a heavily litigated topic in South African law. And in the legal fraternity, you have something called precedent. So when the Labour Court or the Labour Appeal Court or the Constitutional Court makes a judgment on an aspect relating to a strike or a lockout, that law actually becomes binding. It obviously has to be interpreted on a case-to-case level, but it is something quite interesting, and that is something that my colleague Willem will be dealing with, my fellow organizer. We will then discuss with you some practical elements relating to contingency planning for strikes or lockouts. And then lastly, we will be dealing with Q&As. Essentially, we will be answering your questions if you have any questions. I'll now be moving over to the next slide in our webinar. So a strike is economic pressure by design. So what needs to be understood in terms of what a strike constitutes, it is something that effectively is designed to inflict economic harm on an employer. So I know that is a very negative phrasing of the term, but looking at it plainly, it is something that the law makes provision for whereby employees or a union are able to exert a certain amount of influence or pressure on a business to yield to their demands. However, such pressure can only be exercised and induced under relatively, highly regulated legal frameworks. And it's very important to understand where your rights are as an employer, both in terms of strike and lockouts. However, there are some very important aspects that you need to take note of. The concept of no work, no pay. When a workforce is on strike, you as an employer are not obliged to remunerating them for the period that they are on strike. Secondly, there is a minimum of a 48-hour notice that has to be given to you as an employer when a strike occurs. Now, when it comes to people working for the state, there's a slightly longer period, 7 days. We're not going to go into too much detail about this, as I suspect most of the attendees of this webinar are private. I don't see anybody from the state attending this discussion. Just good to know. Lastly, we will also need to point to the fact that if a strike falls within the legal parameters of being lawful, a court is not in a position to get involved unless it crosses a certain boundary relating to derivative misconduct relating to the strike. Alternatively, if the strike is not protected. However, protected strikes cannot be interdicted. It is essentially a power play. In the converse, you as an employer have the right to proceeding with a lockout. So it's not all doom and gloom. There are legal mechanisms for employers to be able to take action and to counter that reality of a strike. I will be discussing that a little bit later. I'm first going to be jumping into discussing strikes specifically. Okay, let's move over to definitions. A strike. So a strike is defined in terms of an act called the Labour Relations Act. So that is basically the piece of legislation in South Africa that regulates and defines what a strike is and sets out very strict rules in terms of under what circumstances a strike can happen, how it can happen, when it can happen, what processes have to be followed. I'm going to read the definition of a strike for you because we're going to be exploring this topic a little bit further, because if it doesn't fall within the definition of a strike, it isn't in fact a strike. And it's very important for you as an employer to be able to understand that certain conduct actually in fact does not constitute a strike, and that a different approach has to be taken. So I'm going to read it. A strike is a partial or complete, concerted refusal to work, or the retardation or obstruction of work by persons who are or who have been employed by the same employer or by different employers for the purpose of remedying a grievance or resolving a dispute in respect of a matter of mutual interest between the employer and the employee. Every reference to work includes overtime work, whether voluntary or compulsory. Now, I understand that's a lot to digest. Don't worry, we're not just going to leave it at that. We're going to go into a lot more detail in relation to the various elements of this this definition, because a lot has been processed, so and dealt with in terms of the courts when it comes to this definition as to what it means. But I'm just going to point out three interesting points that I think you just need to take note of. Dismissed employees can be on strike. So as you can see, this definition also relates to employees who in fact have been dismissed. The second important point is that it relates to different employers. So if you have a business and that business has dealings with another business, the employees of the business that you have dealings with can participate in the strike, and that is what we call a secondary strike. Now, the processes in terms of giving notification in relating to a secondary strike, as well as the topic as a whole, that is something that Willem will be discussing with you a little bit later on. But it's important to understand that it isn't a singular employer. Thirdly, it also relates to overtime work. So an overtime ban is a strike. It does not matter that the overtime was voluntary. So employees can in fact strike about overtime. I'm going to be moving over to the next slide. The three boxes, and all three must be ticked. So these three are absolute requirements for something to constitute a strike. And so effectively, firstly, it needs to be an act or omission. A refusal to work, complete or partial, or retardation or obstruction of work. I'm going to be discussing that with you in a lot more detail shortly. Done in concert. So it cannot be one employee. One employee cannot go on strike. It needs to be more than one employee. One employee going on strike is not a strike. If one employee says they are going on strike, that does not fall within the definition of a strike. It needs to be more than one employee. Now, thirdly, for the purpose of the strike. So a strike needs to be for a reason, to remedy a grievance or resolve a dispute about a matter of mutual interest. So if somebody is on strike, they need to be able to explain to you why they're on strike. It needs to be for a specific reason. It can't just be the fact that somebody doesn't want to come to work. That doesn't constitute a strike. It needs to be for the purposes of exercising pressure on you or exerting pressure on you as an employer to either remedy a grievance or deal with a matter of mutual interest. So, one very important aspect of a strike is the concept of work. So there are two very important qualifiers when it comes to what actually constitutes work. So if performing work does not constitute work, if it relates to performing something that would be breaching the law. So hypothetically speaking, if I were to be running a poaching business in Arniston, and I would be poaching Parliament, and I've got a whole bunch of people working underneath me, and those individuals decide that they are going to go on strike, that would not constitute a strike, and that will not constitute work under the definition of a strike. So they can't go on strike, and I can't hold them obviously liable to do that work, because the work itself would effectively be against the law. Secondly, it cannot be something that is in conflict with health and safety laws. So if, for instance, you have a metal industry, or you have a business that deals in the metal industry, and you have a group of people who are welding, and they are not given the necessary safety goggles, and they decline to do the work in the absence of safety goggles, that would not constitute work under these auspices, because obviously they would possibly develop arch eye and they cannot do the work. Now, I understand that these two concepts are sometimes a little bit less obvious in what I've explained to you right now. So if there is ever a strike, if you are ever subject to a strike, I think it would be best for you to get a second opinion if there is ambiguity relating to it. So the lawfulness of the instruction needs to be effectively be lawful, and the work itself also needs to be lawful for it to fall within the definition of a strike. Okay, so this is quite an interesting one. It does not have to be a walkout. So I think the general perception of what a strike constitutes is that you've got a whole bunch of people outside of your workplace toy, or effectively just refusing to work. It doesn't necessarily have to be that, but I think that is possibly a bit more of a caricature than a reality. There are a number of different ways in which a group of employees can participate in a strike. I'm going to be going through them with you one by one. A complete refusal. Now, this is the classic walkout. Everybody puts their tools down and says, we are not going to continue working until the following demands have been met. That is the complete refusal. The second one is a partial refusal. So they perform some of their duties and refuse the rest. So there's a very interesting case, and it's not one that relates to South African law, but it gives a very interesting demonstration of what would constitute a partial refusal. A few years ago in Japan, they had an incident where the bus drivers working for a bus network that was being operated by a private entity decided to go on strike. However, the disruption that such a strike would cause, according to the drivers of these buses, made them believe that it would possibly cause a negative perception and, cause such terrible disruption in the country that them not doing their work effectively made them disinclined to just not working. So what they did is they decided to effectively let people come onto the buses, but not charge them any fees. So the buses were working and the public were allowed to use the buses. It's just they were all getting free rides. And they were performing part of their work, but driving the buses, but they were not collecting any fees for driving the buses. So that is a good example of a partial refusal to work. Retardation. Now, this is where there is a go slow. I think growing up in South Africa, everybody in one way or another has been affected by a strike. I remember being a child and the petrol attendants all went on strike, but they didn't stop working. They just went on a go slow. So you had this long line of cars outside of petrol stations waiting to be serviced with petrol attendants who were deliberately just doing it as slowly as possible. Effectively still making fuel available to customers, but just doing it in such a way that the whole process and the whole service delivery model was being frustrated. Lastly, an obstruction. So say, for example, you have a logistics company and you have a number of trucks that need to deliver and drop off goods. So an obstruction, for example, would be where the delivery drivers leave materials in front of the loading area. So it's effectively stopping the operations from being able to run properly. So they are effectively still working, but they are arranging the production line in such a way that the production line isn't actually effectively able to work, causing disruptions in the workplace. Now, something very interesting that I would just want to point out with regards to these four examples is the no work, no pay rule. So regardless of which category a strike falls under, in terms of what I've just discussed with you or what I've just put onto the screen, employers are not required to remunerate the employees at all if a strike is taking place. So there is no requirement to pay the employees or the participants of the strike, I should rather say, a pro rata basis in terms of the work that they are rendering. If their conduct falls within this definition, as an employer, you have the right to withholding the salary payments. Okay, let's have a look at lockouts. So as I said before, a strike is something that is initiated by employees. Now, you as an employer you have the right to engage in a process that is what is called a lockout. Now, lockouts, they're not as commonly understood or actioned in South Africa as strikes are, largely because businesses, well, maybe it's just not as visibly obvious, but it's something that businesses do and they can do. And it's basically the counter to a strike. Lockout is defined by Section 213 of the Labour Relations Act, the one that I mentioned earlier. And I'm going to discuss with you the definition of the actual, of what a lockout comprises of. Excuse me. So a lockout is an exclusion by an employer of employees from the employer's workplace for the purposes of compelling the employee to accept a demand in respect of any matter of mutual interest between an employer and employee, whether or not the employer breaches those employees' contracts of employment in the course of or for the purposes of that exclusion. Now, I know that is a mouthful, and I'm going to go into a little bit more detail with you about it because lockouts are also classified into, broadly speaking, what we call offensive and defensive lockouts, and it's very important to understand the distinction between the two. However, for the time being, I'm going to just explain some slightly broader concepts relating to that definition. So, exclusion from the workplace. So, under the old Act, the definition also include cover dismissal and the refusal to rehire. So back in the day, if employees went on strike and they were dismissed, or they were dismissed as a result of the strike, the concept of a lockout applied to them. Now, under the new Labour Relations Act, dismissing employees who engage in a strike constitutes a breach in terms of the Labour Relations Act, and it can actually constitute an automatically unfair dismissal. That does not, however, mean that a retrenchment process cannot be initiated or finalized as a result of a strike. However, that is a very highly debated and contentious legal concept that has been dealt with by the courts, and it's not something that I would encourage anybody to do unless they have a thorough understanding of the legal parameters of such a process. Employees in plural. So when we discussed the concept of a strike, we spoke about the fact that it cannot be done by one employee. Now, effectively, when it comes to a lockout, okay, you cannot exclude one employee from the workplace. There was a case called Schoeman versus Samsung where the sales executive was locked out, and that was deemed to fall outside of the parameters of the definition. As you can see, the definition talks about employees. So you cannot, in the same way that one employee cannot go on strike, you cannot lock out one employee from the workplace, as that would fall outside of the concept of the definition. Now, effectively, in terms of Section 67, you are not required to pay employees if they are on a lockout. So the protection that is afforded to you as an employer, if you decide to initiate a lockout, is that you are not required to actually remunerate the employees that are subjected to the lockout. Okay, so there are effectively two elements, okay? Two elements, both are required for a lockout, okay? It needs to effectively involve an exclusion of employees from the workplace, emphasis being on the plural. It usually involves the closing of the premises. So effectively what happens is that you as an employer say we are proceeding with a lockout. Obviously, having followed the due processes that will be discussed in greater detail a little bit later on, and the premises is closed and they're not given access to the premises, and no element of a concerted action is needed. So this is quite interesting. The parties initiating a strike, as I mentioned, is a number of employees. When it comes to a lockout, provision is made for an employer. So an employer being a singular entity institutes a lockout against employees who are effectively the plural. Now, what is the purpose of a lockout? That's, I think, is probably quite an important question, and I'm going to discuss that with you a bit further. So the purpose of the lockout is to compel employees to accept the demand about a matter of mutual interest. Okay, in the same way that a strike is to compel an employer to accept the demand of mutual interest. Okay, the demand must be stated. So if a lockout is initiated, you need to clearly state what the lockout is about and why it is proceeding and what the demand is. Right? That is extremely important. You may not lock out employees who have made no demand against you and with whom you have no dispute. So I think that is quite self-explanatory. If you do not have a dispute with employees, you cannot put them on a lockout. Okay, I'm going to now move over to the concept of an offensive and a defensive lockout. And the distinction is really, really important, because your right as an employer or HR manager or anybody who is sitting on the fence of being the entity initiating the lockout gives you some very specific responsibilities as well as rights. And depending on whether it is an offensive lockout or defensive lockout, you need to make sure that you are exercising those rights and responsibilities within those parameters. So, an offensive lockout. An offensive lockout is something that is initiated by you as the employer. You have a specific demand and a matter of mutual interest, and you initiate the process. Okay, so it is something that isn't as a result of a strike, it is something that you are initiating. Okay, when you engage in an offensive lockout, you may not employ replacement labor. I think a commonly known term is scab labor. So say, for example, you are running a retail store and you decide to initiate a lockout, and you are initiating it as the party effectively doing an offensive lockout. You cannot get subcontractors or independent contractors to come and do the work of those employees. So if you choose to proceed with an offensive lockout, you need to understand that whatever work those employees were doing is going to stand still. Okay. Now, an offensive lockout is usually utilized for the purposes of breaking a deadlock with a union that is not on strike. So you have had negotiations and a meeting with the union. You guys have not been able to agree to the demands, or you guys have not been able to find consensus, and you as an employer decide, well, as a result of us not being able to reach an agreement with regards to this, we are now going to proceed by excluding the employees from the workplace until they agree to those demands. I know that it makes mention of a union. However, it can also just be a collection of employees. It does not necessarily need to be a union. Okay. So there are very specific procedures in terms of a lockout that you have to follow before you can do it. And Section 64 of the Labor Relations Act spells those out. So you can't, just unilaterally decide to lock up the employees. You have to follow a very specific procedure in order for that lockout to be protected. The second concept that I'm going to discuss is what is called a defensive lockout. Okay. Now, this is something that happens as a result of a strike. So you as an employer are sitting in a situation where there's a strike happening, the employees are on strike, and you decide to, in response to that, commence with a lockout. Now, for defensive lockout, you as an employer are allowed to hire what is called scab labor or replacement labor. So if your employees are on strike and you are that same retail owner that I mentioned earlier on, and you wish to get independent contractors or subcontractors to come in and do that work while those employees are on strike, you are allowed to do so. So your business operations can continue. However, there's a very fine line between a defensive and offensive lockout in the actual play of these sorts of this sort of engagement. And there was recently a case called the TrendStar case that Willem will be discussing with you a little bit later on, which you need to be conscious of before being sure that you are in fact participating or engaging in what is called a defensive lockout. Something quite important is that if a strike is unprotected, you do not need to follow the Section 64 procedure in terms of referring a matter to the Bargaining Council or the CCMA. You are allowed to do a lockout unilaterally. So if the strike is unprotected, you can proceed with a lockout without having to follow the due process. However, as I said, don't assume that the strike is unprotected. I'm going to discuss that a little bit later with you. But if the strike is unprotected, and if that has been corroborated and confirmed by us or whoever your service provider is, then you can initiate a defensive lockout without having to refer the matter to the CCMA or Bargaining Council. Now, the last point is very, very important. you need to keep your demand identical to the one that went to conciliation. So if a Section 64 procedure is initiated, what effectively happens is that a matter is referred to the CCMA or the Bargaining Council, a conciliation takes place, and if the conciliation is not successful, the union will get or the employees will get a certificate to strike. And they may then, as mentioned earlier on, within 48 hours, give you 48 hours notice, not within 48 hours, but give you 48 hours notice to proceed with the strike. If your demand while they are on strike changes and you are busy with a defensive lockout, that could possibly become an offensive lockout, which then means you are not entitled to utilizing replacement labor. So you need to be very careful to make sure that in your negotiations with the workers or the union, whoever you are negotiating with, who are sitting on the other side of the table, your demand when you proceed with a defensive lockout in response to their demand does not change. It's important that they stay the same. Okay. Now, you'll see that right at the bottom, I make mention of maintenance services and that replacement labor may not be used regardless of if it's an offensive or a defensive lockout. I will discuss it with you a little bit later on in a later slide. Okay, let's quickly have a look at a comparison table between a strike and a lockout. Excuse me. So a strike is a constitutional right. The Constitution of South Africa, which is basically the highest law in South Africa, specifically makes mention of the right to strike. Now, what is interesting is that it does not actually make mention of a lockout. The interim constitution between 1990 and 1994, interestingly enough, made specific provisions for employers to initiate lockouts. However, that did not carry forward to the final constitution that was passed. That doesn't mean that you can't proceed with a lockout. It just means that the legal mechanism that you use to initiate a lockout is something that emanates from the Labour Relations Act, not the Constitution. So, in terms of a strike, who can strike? 2 or more employees in concert. So it cannot just be one employee. In terms of a lockout, one employer alone is the person or the party that is initiating the lockout. Against whom is a strike directed? A strike is directed at employer or another employer in the case of a secondary strike. I know I've made mention of secondary strikes. I'm not going to jump into too much detail, but I know that Willem is really excited to discuss secondary strikes with you. So we'll discuss that a little bit later on so that you understand secondary strikes, because it is quite important, and how it can impact your business and how you respond needs to fall within these concepts. Okay, against whom is a lockout directed? Employees with whom you are in dispute with only. Okay, notice. So if a strike is initiated, they need to give the employer 48 hours notice, and as mentioned, 7 days notice in the event that it's the state. In the event of a lockout, it is also a 48 hours notice in writing. Both have to be in writing. Now, as I mentioned, if it is an unprotected strike, you are not required to give that 48 hours notice, as the act of engaging in the strike is not afforded the same protections as a protected strike by the Labour Relations Act. Okay, replacement labor. So in the event of the strike, you may utilize replacement labor during a protected strike. Okay, so if the strike is initiated by employees or union, you may utilize replacement labor. In terms of lockouts, you may only use replacement labor if it is in response to a strike. So you are the defending party, not the party that is initiating the lockout. Okay. The last concept, which is really important to remember, is that regardless of if it is a strike or a lockout, the no work, no pay principle applies. Now, as businesses, if you are proceeding with a offensive lockout, your production effectively comes to a halt. So your ability to generate revenue is effectively curtailed, or the tap is turned off on that. So initiating an offensive lockout is something that an employer needs to do with the full knowledge that they will not be able to generate revenue over that period of time, because they cannot replace it as the workers that are on strike. However, if you as an employer are subjected to an unprotected strike, or you are participating in a defensive lockout, you may employ workers, which means that your business can operate. How effectively is obviously depends on a number of things. If it's highly skilled workers and they cannot be replaced, then it might be difficult to find scab labor. But, I think that's something that's very subjective and depending on circumstances. But just understanding those two distinctions is quite important. Excuse me. Okay, I'm now going to move over to what you can strike about. So I know that mention has been made of the concept matters of mutual interest. Okay, so matters of mutual interest. Okay, that relates to terms and conditions of employment, wages, hours, and shifts. Okay, it might relate to health and safety processes, disciplinary and grievance processes, and retrenchment procedures. Retrenchment procedures is quite an interesting one. I'll discuss it with you a little bit later. Job security and dismissal of workers subject to rights disputes are barred. Recognition of organizational rights and a refusal to bargain. So those all fall within the concept of matters of mutual interest. There is a lot of case law in terms of what is defined as matters of mutual interest. The definition is generally understood to be quite broad. So I know that I've given you a list over here. However, it's something that is invariably argued about because obviously the parties that are initiating the action will want it to fall within their objectives, and sometimes those the definition is maybe given a slightly more creative interpretation than the law prescribes, and that can result in disputes about that. But broadly speaking, that is what matters of mutual interest are. Now, what falls outside of those concepts are political demands, which are aimed at the government rather than at you. Now, there's a subject there's a process called a protest action. That is where it's normally done as a result of a federation of unions striking about living conditions and socio-economic demands. That is something quite different, and that isn't a strike. The concept of no work, no pay also applies, but the procedure that is followed, as well as the notice period, differs quite a lot from a strike. So that isn't a strike, that is protest action, and it's governed by a different section in terms of the Labour Relations Act. Okay. What falls outside of the concepts of mutual interest is obviously demands that would require you to break the law. So there was quite an interesting case a couple of years ago at a mine where there was a number of workers who were members of a union. I cannot recall the name of the union, and they demanded that a certain manager be dismissed. And the argument was that it was a matter of mutual interest or grievance and should be afforded the protection as laid out by the law. The matter eventually went to court, and a final decision was made that such a demand was not lawful because the manager was obviously afforded the protections of any other employee in terms of the processes. So it was considered to be a unlawful demand, and the strike was not deemed to the strike was not deemed to be protected because it would not be legally sound to dismissing somebody simply because a number of employees don't like this person and demand that person to be dismissed. Obviously, there are different processes. If there is something happening at a workplace where a member of staff is engaged in serious misconduct and is possibly engaging in creating a dangerous working environment due to not complying with health and safety rules, or getting into fistfights with people, but that is something that still requires a disciplinary process to be initiated. But that falls outside of the parameters of this webinar, so I'm not going to go into too much detail about that. What I just want you to remember is that the demand needs to be a lawful demand. Okay. Lastly, anything already regulated by a binding or collective agreement or award cannot give a basis for a strike to commence. I will discuss that in a little bit more detail in a later slide. Okay, rights disputes and interest disputes. Okay, so they may strike over interests, they may not strike over rights. So what that basically means is that employees may proceed with going on strike about something that is called an interest dispute. So that relates to wages and increased demands. And I think that's probably one of the most commonly striked about subjects, is when workers or employees need or demand to be paid a higher salary. A change of shifts or working hour arrangements, that is a basis that could potentially result in a strike, and that is considered to be an interest dispute and is strikeable. Benefits, allowances, and bonuses that are not already regulated. So if, for instance, you fall under the Basic Conditions of Employment Act and the employees demand to be given a provident or pension fund, that would be deemed to be a strikeable right. If, however, you fall under a bargaining council where there is already a provident or pension fund and the contributions are being made, that wouldn't give a basis for a strike to be initiated. Lastly, recognition of organizational rights and refusal to bargain. So organizational rights are basically rights that a union wishes to exercise in the workplace. And there's a whole list of those rights. I think that organizational rights is probably a subject that could give a basis to an entire webinar by itself. So I'm not going to speak too much about that. But effectively what happens is that a union arrives at your workplace and says that they are representing a certain percentage of the workplace and they want to be given certain rights, such as deductions from the employee's salaries to be paid over to the union as union fees, access to the workplace, and quite a few others. And you as an employer simply say, no, I'm not willing to give you those rights. That is something that can be struck upon. And obviously, refusal to bargain. I think that one, as per definition, explains itself. Now, rights disputes are not strikeable. So unfair dismissal, including constructive dismissal. If employees are dismissed as a result of misconduct, they cannot go on strike about that. That is something that has to be referred. They need to refer to either the Bargaining Council or the CCMA for it to be attended to over there. Okay. Unfair labor practices, promotions, benefits, training, suspension, and discipline short of dismissal. So if, for example, warning letters are issued to employees for misconduct, that is not something that can be striked about. That is something that has to be also referred to the Bargaining Council or the CCMA. And interpretation and application of collective agreements, that is not something that constitutes an interest dispute. And lastly, freedom of association complaints, these need to go to the labor court. Okay. Excuse me, I'm just going to have a quick sip of water. Let's move over to the next topic of discussion. Is a strike allowed at all? So there are, broadly speaking, 6 bars on which a strike may not be initiated about. Okay, if a collective agreement prohibits a strike. So if there is a collective agreement, being an agreement reached between an employer and employees, and it is a signed agreement, and it specifically binds the parties on certain matters that would fall under the concept of a dispute of interest, a strike cannot be initiated on those bases because the agreement stands in its place. And those agreements will usually, or they will state that that it's being categorized as what you call a peace clause, which means that it is binding on both of the parties for as long as that agreement is in place. Okay, an agreement that requires arbitration. So if there is an agreement that expressly says this dispute has to go to arbitration, such a matter cannot be referred to and a strike requested on it, because the parties have effectively agreed that that specific matter needs to be dealt with in terms of arbitration. If it is a right dispute, as I mentioned earlier on, rights disputes are not something that can be striked about. We spoke about disciplinary action. We spoke about dismissals, including constructive dismissals. You cannot go on strike about those sorts of concepts. Okay. There is, however, one exception, and this is something quite interesting, and it's not something that happens very often, and that's in terms of large-scale retrenchments. So in terms of employment law in South Africa, you have something called a small-scale and a large-scale retrenchment, which probably also warrants an entire webinar by itself. But what I want you to walk away from just understanding on the side in relation to strikes is that if there is a large-scale retrenchment taking place, the employees may initiate a strike on the substantive fairness, not the procedural fairness, the substantive fairness. That is the content of the fairness of a dismissal. I don't want to go into too much detail about that, but yeah, there is a right for employees to go on strike on retrenchments that constitute large-scale retrenchments. Fourthly, essential and maintenance services. So essential and maintenance services is something that I will be discussing with you in a separate slide shortly. But if it falls into those categories, strike may not be initiated. An award and agreement that regulates it. So if there has been a private arbitration award relating to the matter that the employees want to go on strike about, it cannot be referred back and a strike requested on something that has already been arbitrated and a decision has been made by it. Lastly, a determination that regulates it. So, for example, if there is a sectoral determination relating to wages, such a matter cannot be employees cannot go on strike about that for the first 12 months that it is in operation. So if there's a sectoral determination, for instance, in the farming industry, and minimum wages have been set down for that, for the next 12 months from the date that sectoral determination regulates those wage agreements, which have been promulgated by the Minister of Employment, the employees cannot go on strike about that. But there's a 12-month period that is applicable to. Okay. As mentioned before, there is something called essential services and maintenance services. I'm not going to discuss with you what constitutes an essential services. Okay, so what actually is about essential services? An essential service is a service in which the interruption of which endangers the life and personal safety or health of the whole or any part of a population. Parliamentary services, the South African Police Services, and anything that has been assigned by the Essential Services Committee. So the Essential Services Committee is a committee that basically investigates certain operations, and they basically have the right to be able to designate specific services to fall within the definition of essential services as defined by the Act, being something that could, if a strike were to occur, it would endanger the life and safety and personal safety and health and safety of the population. Now, there are a couple of designated examples of that. The Essential Services Committee has designated the following operations as being essential services, despite the fact that they are not spelled out by the Act. They are air and traffic control, weather services weather service that supports it, municipal traffic and policing, municipal health services, and municipal security, water supply and distribution, generation, transmissions of power, distributions, and obviously firefighting. Correctional services, you can't have the correctional services going on strike because who's going to look after the prisoners? And yes, any services that require the courts to function, and as well as blood transfusion. So those are examples of services that have been deemed to be essential services, and a strike cannot occur in those industries. There is, however, a small proviso, and that is minimum services. So simply because they have been designated by the Essential Services Commission as being services where a strike cannot occur, an agreement can, however, be reached whereby minimum services in relation to those functions can still be given, and the other employees can go on strike. So say, for example, this is just very broadly speaking, if the South African police want to go on strike, if there is an agreement that there will be a 20% reduction, 20% of the workforce will go on strike and 80% will remain at work, then that will constitute a minimum service, but that can only be done once it has been actually ratified by the Essential Services Committee. I'm now going to move over to something called maintenance services. So maintenance services is a service is a maintenance service if the interruption would cause material physical destruction to any working area, plant, or machinery. So some good examples of that is deep level mining, where you have mining shafts that require water to be pumped out. If you were to stop that, there would potentially all of the mining shafts would flood. Or, for example, furnaces. If you have furnaces that need to continuously be running and if they were not to run, it could potentially cause serious damage to the working area or plant. That would be what we would consider to be a maintenance service. Now, a maintenance service is something that is usually what constitutes a maintenance service is a bit broader than an essential service. And the reason I say that is that employers and unions or employees can engage in discussions whereby they say this part of this business operation constitutes a maintenance service, and if work stops in that service, it's going to cause serious damage to the business. Now, just remember that a strike isn't done for the purposes of destroying a business, because if the business is destroyed and it's not able to operate anymore, the job security of those workers is effectively completely gone. So there is definitely a bit of a balancing act that has to be reached. So if, for instance, you were to, and a good example would be Saldanha Steel, if everybody there, unless Saldanha Steel is no longer operating to the best of my knowledge, but if everybody there were to go on strike and they just let the furnaces burn out and, they allowed all of that metal to set inside of those massive containers that hold the molten steel, the business might actually close down and all of those jobs would possibly be lost. So there is, if your business operates in a service where the cessation or the stopping of your entire business from running or your factory from running could potentially cause serious material physical destruction, there is a basis for you to approach the union or the workers and say, listen, let's consider the following aspect of the business as a maintenance service, and they are precluded from going on strike. Now, if such an agreement cannot be reached, you as an employer, you have the right to go to approach the Essential Services Committee to have an area designated as a maintenance service. Okay, so employees providing it may not strike and may not be locked out. So you cannot lock out employees who are falling under what is deemed a maintenance service, and they may not go on strike. However, there are a couple of catches that need to be. There are a couple of points that you just need to take note of as an employer when you apply or agree for a sector of your business to be deemed a maintenance service. Okay, so if you have a sector of your business designated as a maintenance service, your entire business, regardless of if you choose to if you choose to initiate a defensive or offensive lockout, you are effectively prohibited from hiring replacement labor or scab labor. So obviously, aside from the employees who are working in the maintenance service, the remainder of the business cannot be, you cannot absorb scab labor into the remainder of the business. So there is a bit of a weighing off in terms of this. So there are benefits to it, and it's an absolute necessity for certain businesses to have these designations. However, it doesn't come at no price. It does limit your right as an employer to initiate an offensive lockout and then commence with initiating or bringing in scab labor to replace those workers that are on strike. Okay, so yeah, I'm going to move over to the next slide. Protected and unprotected strike. Now, this is where my colleague Willem will be taking over, and I'm going to have a sip of water.
Thank you, everyone. Thank you, Konrad. I just need to advise you before, my English isn't as good as my colleagues here, so I'm going to do a lot of reading, but it will still be pertaining to the slides. So yes, when is a strike protected and when it is not? It's in short, what I'm going to say here, protected strike is not necessarily a lawful free-for-all. And unprotected strike does not automatically mean that you can dismiss everyone. The employer first asks whether the proper procedure was followed and whether the strike is protected. If it is protected, employees cannot be dismissed or simply for participating, but misconduct can still be disciplined. If it is unprotected, the employer has more remedies, including an interdict, discipline, and potentially dismissal. But fairness, proper ultimatums, and consultation with the union, evidence and proportionality still matters. Where am I now? The basic starting point is that employees can't simply decide today that they are going to go on strike tomorrow. There is a process that normally needs to be followed. The dispute must first be referred to the relevant bargaining council, to the CCMA, and if to the CCMA, if there is no council, the parties then have an opportunity to conciliate the dispute. Once a certificate of non-resolution has been issued, or 30 days have passed without a certificate being issued, a written strike notice can normally be given. Again, as my colleague mentioned earlier, it should be given at least 48 hours prior to participating in the strike, or even 7 days if the state is the employer, as my colleague mentioned earlier. If these steps are followed and there is no Section 65 prohibition, the strike will generally be protected. Okay, now also, when it comes to the strike itself, a strike notice is important, but the courts do not expect a legal essay. It should just be clear and simple. It must just be in writing, and it must tell the employer with reasonable certainty what the strike, when the strike is going to start, and what the employer can prepare. And my colleague mentioned earlier case law in ceramic industries. Wording such as at any time after 48 hours was not sufficiently clear in the circumstances of a shift operation. On the other hand, another case, Western Platinum, shows that the courts will not be unnecessarily technical if the employer can reasonably understand when the strike will commence. Importantly, employees who are not members of the union giving notice can also join the protected strike without giving a separate notice. This was confirmed by the Constitutional Court in Equity Aviation, another case. Now we come to secret ballots. Secret ballots are a bit more complicated. The presentation refers to Male, the SA versus NUMSA, Foscor versus NUMSA, where the Labour Court interdicted strikes because the union had not complied with the transitional secret ballot requirement. However, an employer cannot simply argue that every strike is unprotected because the union did not hold a ballot. Section 67(7) of the LRA limits when failure to comply with the union's own ballot provisions can be used to attack protected status of the strike. So practically, you need to look at the union's registered constitution and applicable statutory requirements first. A right to strike does not necessarily disappear just because the employees wait before using it. If you look at Tiger Wheels, PSA versus the Minister of Justice and the Western Platinum cases, it shows that a delay does not automatically mean that the right has been abandoned. Similarly, if employees suspend a strike and later resume it, it does not necessarily mean that they must start the entire process over again. Still on the same slide. There we go. Refusal to bargain disputes. A refusal to bargain dispute has an extra step. This can include refusing to recognize a union, withdrawing recognition, disputes about the bargaining unit or bargaining level, or even disputes about the issues should be bargainized over. After conciliation fails, an advisory arbitration award must first be obtained before the parties can move to strike or a lockout action. The award itself is not binding, but the process must still be followed, the due process. Now, my colleague mentioned earlier about a secondary strike. A secondary strike is where your employees strike in support of employees involved in a dispute with another employer. Now, for this to be protected, the primary strike must itself be protected. The secondary employer must receive the required notice, and the secondary strike must be reasonable in relation to the effect that it is likely to have on the primary employer. Now, in another case, the UMCO versus Anglo Gold Ashanti, the Constitutional Court confirmed that proportionality is important. That means you have to look at the harm being caused to the secondary employer compared with the pressure the strike can realistically place on the primary employer. Protest action. Protest action is different from any ordinary strike, as mentioned before. It normally concerns broader socio-economic interest of workers rather than a dispute that the employer can simply settle. It follows the Section 77 NEDLAC process rather than the normal strike procedure. If the protest action is protected, employees receive the similar protection against dismissal, although no work, no pay still applies, as also mentioned before. Now, what can an employer do during, what can an employer do during a protected strike? The most important rule, as we've emphasized before, is no work, no pay. Employees participating in a protected strike are protected against dismissal for merely striking, but that does not mean the employer may continue, that does not mean that the employer must continue paying them. The employer may generally withhold remuneration for the period that the employees choose not to work, that they were on strike. There is an important exception involving basic amenities. If the employer normally provides such as accommodation or food, and the employees or union ask for those basic amenities to continue, the employer must generally continue providing them. The employer can later seek to recover their value, but simply cannot deduct the amount from the employer's wages. Looking for replacement labor now. There we go, replacement labor. Replacement labor can generally be used during a strike, as mentioned earlier, and it can also be used during a defensive lockout, meaning a lockout, as my colleague mentioned earlier, that is actually in response to a strike. But replacement labor cannot generally be used during an offensive lockout, also as mentioned earlier, where the employer is the one who initiated the lockout to force employees to accept the employer's demands. There are also restrictions involving maintenance services. Employees are allowed to picket, but a picket is not a free-for-all. They may gather, sing, chant, carry placards to try to persuade customers, suppliers, or replacement workers. But what they may not do is block access, intimidate people, threaten anyone, damage property, or carry weapons. Picketing inside the employer's premises requires permission, although permission may not be unreasonably withheld by the employer himself. This is why proper picketing rules are important. Ideally, the employer and union should agree beforehand where the employees may picket, how many people may be there, who the marshals are, how vehicles and non-strikers will be able to enter the premises, and what happens if the rules are breached. This avoids trying to negotiate the rules while hundreds of people are already standing outside a gate. Protected strike protects participation in the strike. It does not protect misconduct, assault, intimidation, damage to property, and similar misconduct can still lead to disciplinary action and dismissal. The important thing for the employer is evidence. For example, video footage, photographs, or contemporaneous notes are extremely useful. As I said, my English is not as good as my colleagues, but you must still be able to link the individual employee to the misconduct. Simply saying the employee was part of a strike is not enough, or anything like that, to institute any disciplinary action against said employee. The same principle applies when approaching the Labour Court for an interdict. After the Constitutional Court's decision in Oak Valley states, employers cannot simply cite the union and hundreds of employees and ask the court to stop everyone from doing anything unlawful. There needs to be some factual link between the people who you are trying to get the interdict and unlawful conduct or threatened conduct. Now, what changes if the strike is unprotected? An unprotected strike gives the employer more options. The employer can approach the Labour Court urgently for an interdict, may claim just and equitable compensation for losses caused by an unprotected strike and can discipline employees for participating in it. However, participation in an unprotected strike does not automatically justify a dismissal. The circumstances still need to be considered. Compensation also does not automatically mean recovering every rand the employer lost. The Labour Court looks at what is just and what is equitable. In the Rustenburg Platinum case, as an example, where the alleged loss was around 15 million rand, the compensation that was awarded was only 100,000 rand. The point was that Section 68 compensation is not simply a damages calculation.
I think that's a very interesting point that you just mentioned there, Willem. And it's not something that people know about, is that if you as a business owner are subjected to a unprotected strike, you can actually recover your monetary damages from employees or the union if the union is the party that initiated it. It doesn't happen, and I think the case it doesn't happen very often because I think the courts are generally hesitant to
give damages.
Yes, that's right. They are hesitant to give damages, but that's still, if, for instance, I recall a couple of years ago, I was dealing with a strike up on the West Coast on a mine, and they were subcontracting on that mine. And with the member of the employees organization was subcontracting on that mine, and they were basically being penalized for every day that they were overdue in terms of the contract being finalized, and an unprotected strike had been initiated. But it's very difficult to recover money from employees who are not paying salaries.
No, you can't just say ballpark 15 million, this is what I lost, this is what I'm going to recover.
Yeah.
There's a specific calculation. Like I said, Section 68 compensation. It's not just damages.
Absolutely, but it also gives you the rights, but informing the people that are participating in an unprotected strike that you reserve your right to recover the damages is something that can go quite a long way in getting people around the table to talk about it, right?
Yeah.
Okay. Yeah.
Now, and so before dismissing employees, the ultimatum is extremely important. As we all know about ultimatums, the employer should contact the union, clearly tell the employees that the strike is unprotected, tell them when they must return to work, and explain what may happen if they do not. They must also be given a genuine opportunity to consider the ultimatum and return. What I mean by that is if you give an ultimatum, I'm going to use a very simple example now. Let's say one of our employees goes on strike, or employees, plural, goes on strike, and we give them an ultimatum that they need to return to work within the next 5 minutes. That's in my opinion, that's not sufficient time for them to consider the ultimatum. It has to be reasonable.
Well, when you say that, you mean that they need to be able to understand what you're actually putting to them.
Yes.
And they need to be given a little bit of time. And what do you think would be a reasonable period of time? I know it's circumstantial.
From experience, I would say 30 minutes.
30 minutes. So if you have an unprotected strike participating, you go to the workers and you say to them, here's the ultimatum. You've got 30 minutes. Yeah.
That's from experience, that's what I've always done.
Yes. Okay.
That's also part of case law. The Salmon Court case is particularly important. Also, UMCO on behalf of Toronto, there's a Salmon Court Western Chrome Mines. It's that specific case. Employees complied with the ultimatum and returned to work, but were nevertheless dismissed for participating in the strike. The Labour Appeal Court found the dismissal substantively unfair. In simple terms, if you tell employees, return by this time, or you may be dismissed, and they comply, you cannot orderly move the goalpost afterwards and dismiss them for the very strike conduct covered by the ultimatum. If dismissal is being considered, look at the whole picture. First of all, how serious was the breach? Number one, did the employees attempt to comply with the Labour Relations Act? Was this a deliberate wildcat strike, or did the employer do something unreasonable that provoked the strike? Was dismissal really proportionate? And then procedurally communicate with the union, issue a proper ultimatum, give employees time to respond, and provide some form of hearing before dismissals. Now we need to look at case law. That's if we're going to dismiss recent cases. Now, if you look at the case Nimsal versus Trendstar, my colleague mentioned this case earlier. This case significantly affects replacement labor. NUMSA members went on strike and later suspended the strike and tendered their services. TrendStar wanted to continue with a lockout and use replacement workers. However, the Constitutional Court held that the ability to use replacement labor only exists while the lockout is genuinely in response to a strike. Once a strike is suspended and the employees tenure their services, there is no longer a live strike for that purpose. The employer can continue with the lockout, but then cannot rely on the exception to bring in replacement labor. This is also correctly reflected in the presentation and the case of NUMSA versus TrendStar, this case we just mentioned now.
It's quite an interesting case. So basically what happened, I stand to correction in terms of the exact process, but I think what had happened was NUMSA had initiated a strike.
Yes, NUMSA had initiated the strike,
yes,
but the strike was then relieved.
So they said we are going to come back to work on Monday.
Yes, and then the employer still continued to use replacement labor.
Scab labor, yes.
Yes, so they then went from the employees who initiated the strike, the union, to the employer who continued with it.
Which actually got rid of the employer's right to utilize replacement labor for that duration. I see. So there's a very clear, you need to be very careful in terms of understanding when you are moving from an offensive to a defensive lockout.
Yes.
Yes, okay.
In this case specifically, it was a defensive lockout.
It started off as a defensive lockout.
Yes.
And then because they refused them access after they had said, we are willing to come back to work, it became
it became an offensive lockout. And as you mentioned earlier,
yes,
to all our members, then you're not allowed to utilize scab labor.
Okay, interesting.
In SMIEO versus Massmart Holdings, the Constitutional Court 2026, this is also a very recent and important case. The strike itself was protected, but Massmart alleged that the employees engaged in unlawful conduct during the strike, including intimidation, obstruction, and property damage. Massmart tried to claim compensation under Section 68, as we mentioned earlier, Section 68 in the Labour Court. The Constitutional Court held that Section 68(1)(b) applies to unprotected strike or lockouts. It cannot be used simply because unlawful conduct took place during an otherwise protected strike. The damages claim arising from an unlawful conduct during a protected strike must instead be pursued on ordinary delictual principles in the High Court.
So basically what you're saying is that delictually meaning that you just have to follow the normal legal processes to recover damages.
Normal legal processes.
Okay. So if, for example, somebody, sets a car on fire and it's a protected strike, you can't necessarily recover the money from the union. You have to follow the normal legal process.
Yes.
But you can recover your money.
Yes, you can recover your money.
It's just not Labour Court, it's the High Court.
Yes.
Okay.
This is also correctly cited as, okay, sorry, it's the same case. Universal Product Network versus Mbatsana. In this matter, around 256 employees were dismissed for misconduct associated with a protected strike and picketing. The CCMA first found that the dismissals were substantively fair, but procedurally unfair, and awarded 1 month's remuneration. The Labour Court effectively treated the serious procedural defects as making the dismissals substantively unfair, as well as ordered reinstatement. The Labour Appeal Court then disagreed. It made the important point that procedural fairness and substantive fairness are separate questions. A badly handled disciplinary process does not automatically mean that there was no valid substantive reasons for a dismissal. There we go. The next case will be UMCO on behalf of Matabele. This case also comes up quite often. This case shows why the wording of disciplinary charges matter. We can also do a separate webinar on this alone. Why disciplinary charges matter. 4 employees were dismissed for misconduct involving sabotage and interference with security during an unprotected strike. Keep in mind, unprotected strike. The issue was whether the matter belonged to the Labour Court because it arose during unprotected industrial action. The court essentially looked at the true reason for dismissal. They were dismissed for the separate misconduct rather than merely for participating in a strike. That meant the CCMA had jurisdiction. So when drafting the charges, one should make clear that whether you are charging the employee for participating in an unprotected strike or for a separate misconduct committed during the strike. For example, as you would know, it's an unprotected strike, then they prohibit people from coming into there's intimidation or anything of that sort. That will be the difference, point of difference in the matter. In NIM versus baseline civil contractors, this is a useful warning to employers, this case. Employer changed the normal payment date of annual attendance bonus at short notice without proper consultation. Employees responded with an unprotected strike and were eventually dismissed. Although the strike was unprotected, the Labour Court found the dismissal substantively unfair because the employer's own unreasonable conduct had played an important role in causing the strike. Reinstatement was then ordered. The lesson that one should learn there is that an employer cannot look only at the fact that the strike was unprotected. There has to be reasons for that. And if the employer, in this case, I wouldn't say initiated, but enticed it, then it will be a unfair dismissal.
It seems to me as though it's a very I mean, I know there's case law on this, but it's a very subjective sort of interpretation, and you need to look at every single, if you are subjected to an unprotected strike, you need to look at the situation very holistically and say, okay, what is actually going on here? Why is it happening? What steps have we taken to try to resolve the situation? Are the employees being unreasonable? And you need to, at the end of that inquiry, be able to show that you are reasonable at every step of the inquiry. I mean, dismissals are possible, but
dismissals
are possible for unprotected strikes. But there are some, there's quite, it's almost like a bit of a landmark. There's a lot of mistakes that you can do along the way that would deem a dismissal unfair for an unprotected strike, but it is possible.
That's what I'm saying. The court will also ask what caused the strike in the first place. So if the strike was caused by the conduct of the employer, dismissal will be unfair.
Okay.
What caused the strike in the first place and whether the dismissal was proportionate.
Do you think that progressive discipline might be permitted under those circumstances?
Not if, like I said, not if the employer is the one
initiated. But every case has to be judged on its own merits, right?
Yes, every case has to be judged by their own merits. That's all from me.
Is that all from you? Okay. I'm going to be moving over to dealing with some of the practical aspects of a strike. So, a strike is obviously something that we've discussed with you now in a very technical aspect. I hope it wasn't too technical, but I hope you've been given sort of an understanding in terms of what a strike and what a lockout constitutes. Now, as we mentioned at the beginning, no business in South Africa is strike proof. And if you are subjected to a strike, or a strike is something that is pending, it's very important to be ready for it. And that is where the concept of maybe having a contingency pack will go a very, very long way in assisting you as the person who's effectively on the front line to make sure that the first steps that you take are the right steps. Now, so you are sitting and the business is carrying on, and all of a sudden, boom, you get a written notification from a union or employee saying, in 48 hours, we are going to be going on strike. Now, ideally, you want to make sure that all of these processes are already in place and you understand what you're going to do if something like that happens. Now, the first thing is to make sure that you have a union file. If it is a union that is writing to you, make sure that you are familiar with the union itself, and that it is in fact a registered union. Certain unions are not registered. So if it is a union writing to you on behalf of their members, and you've never ever heard from them before, it's worth inquiring into who they are.
Always ask for their certificate of registration.
Absolutely. You need to know their constitution and see their certificate of registration. If you have a recognition agreement with the union, make sure that you are familiar with that recognition agreement with that union. Okay. Very important is picketing rules. And this is something that I just want to chat to you all about a little bit more. So picketing is a very specific kind of act. It's basically where people are standing with placards outside of your premises saying that Pick n Pay or whoever it is,
just a demonstration that they are on strike.
And they've got
they make the public aware of it.
Yeah, and it's normally in pickets that you start sitting in a situation where there's violence and those sorts of things, because especially if you have replacement labor coming in, because they invariably end up standing at the gate of the workplace and they're shouting and screaming. And I mean, that's where things can get out of hand. People get carried away. Before you know,
rules are important.
Yeah, precisely. So if a strike is something that is something that is going to be happening, there must be picketing rules in place. You need to make sure that you have a very clear understanding and written understanding with the union or the workers that stipulates what the picketing rules are. As a matter of fact, as I understand it, there's actually a legal requirement for the CCMA to ensure that picketing rules are put in place before a certificate is issued. Okay. From a practical perspective, you need to make sure that you have the names and numbers of the union as well as the union officials, the union officials available, so that there is a continuous line of communication, so that the whole situation can be controlled, and that the opposing side on the strike can be spoken to and negotiated with if negotiation is something that you are wishing to do, as well as the fact that lockout notices and those sorts of documents can be served if you want to follow those processes. You don't want to be in a situation where a strike is commencing and you don't know who the union is, you don't know the contact number at the union, you've sort of been blindsided by the whole situation. So make sure that your union file is in order, okay? Secondly, it is really, really important that you have a clear understanding of just understand that this is not applicable to all businesses, but certain businesses will be impacted by this. Is your business falling under what constitutes an essential or a maintenance service? Okay, that is something that is usually, if it's a maintenance service, it's usually as a result of you having an agreement with the union or having it designated by the Essential Services Committee. Alternatively, you can contact them and find out from them if your line of work has been designated as an essential service or a maintenance service. Okay. Thirdly, if it is a defensive lockout, you need to make sure that replacement labor is been made available well in advance. So if you are, for instance, running a hotel, and your employees all go on strike and you have all of the guests at the hotel and all of a sudden there's nobody in the kitchen to cook for the staff, you want to make sure that you have the right people who can come into the situation and make sure that your guests are being looked after. So replacement labor is something that you need to plan for in advance. Make sure that you know your industry, know who can potentially be an offer on a temporary basis. Of course, you're not going to hire them. Don't give them all permanent contract. No. Yeah. Make sure that you have a contract with a service provider, an external service provider, who can provide you temporary services. And as I said, don't give them all permanent contracts. We'll find ourselves very busy with that if you were to down that road. Okay. Fourthly, incident reporting. This is really, really important. So, as I mentioned before, situations can need to make your thing, and it's almost like keeping a narrative book of what is happening. 0800 employees gather outside of the workplace with protest pickets. Are we still on? Oh gosh, what's just happened? We are on hold for some other reason.
Konrad, we can see you and hear you, but you are frozen.
Hello there. Sorry about that. I don't know why we disappeared. I don't think there was a commercial break. Let me get back to sharing. Okie dokes. There we go. Okay. That's a message coming through. Okay, so incident recording. So you want to make sure that if a strike is happening, everything is recorded, because if it ends up being something that results in litigation, we're on hold again. My goodness. I don't know what's going on.
Hi, Konrad. We can hear you. We just seem to have a bit of a lag.
Okay. My apologies about that. We seem to be bumping into a couple of technical gremlins. I will do this quickly just to make sure that we're able to get to the conclusion of this presentation, as well as get some questions and answers afterwards. So effectively, you want to make sure that you have a way of ensuring that everything is kept on record as to what's happening, when it's happening, and that all of that information is kept stored. A communication plan. So this is where I mentioned earlier on, it's really important to be able to engage in meaningful discussions and have a clear line of communication with whoever is sitting at the other side of the table of the strike. Lastly, you need to make sure that you have a bundle of standard documents. Now, an ultimatum that Willem was speaking about earlier on, for instance, in an unprotected strike, you want to make sure that you have that documentation ready to hand over to the people that are participating in an unprotected strike, instructing them that what they're doing is unlawful, that what they are doing constitutes potential intellectual damages, and that
need to return.
And by when they need to return, make that 15 minutes, 20 minutes, half an hour. You want to have that documentation at your fingertips, because if you are sitting in a situation where an ultimatum is only issued an hour after the unprotected strike has commenced, it only causes more disruptions in terms of production time.
Seriously, too.
Yes, exactly. Yeah, and how quickly you can actually resolve it. Okay, I'm now going to move over to the next slide, which is the checklist. So beforehand, okay, so before strike commences, you want to make sure that there are picketing rules in place, and that if you have a recognition agreement, that those picketing rules are kept in the actual recognition agreement. Get the registered trade union's constitution. Know what part of your business constitutes essential and maintenance services. Decide who records the incidences. So you want to have a designated person who is keeping record of everything that is happening. And lastly, make sure that you have replacement labor. However, just take note of what we discussed about the Trendstar case. Just with regards to picketing, and this is quite important, and this is very helpful to have. If it is a protected or unprotected strike and things are getting out of hand, use your phone, take videos. That is something that you can use as evidence in the event that something goes wrong. You really want to make sure that you have all of that information at your disposal. If there are a couple of employees who are engaging, for instance, in violence, you need to be able to know who those individuals are, as you cannot simply cite all of the employees in an incident like that. You need to be able to identify those people. So make sure that you have your video footage, that you have your camera, that you have as much information as possible about what happened, when it happened, who did what, so that if the situation results in further legal steps having to be taken, that you have your evidence together. During the strike, as I mentioned back before, make sure that you diarize everything. Withhold pay, as I mentioned before, it's no work, no pay. So the people that are participating in the strike do not need to be remunerated. Photograph and log everything with names, dates, and times. Keep talking to the union. Make sure that they are kept in communication in relation to what's happening. And yeah, very importantly, don't give bonuses to employees that aren't striking. Something like that can go sideways, and there is case law in relation to that, where certain businesses have in the past given financial bonuses to employees that are not striking. That unfortunately wouldn't fall within the parameters of employment law in South Africa. Once the strike has been completed, you can initiate disciplinary action where it is warranted. Okay, so in terms of the actual misconduct that happened on the strike, make sure that you separate the strike from the actual misconduct. So if somebody assaulted somebody on the strike, you're not going to charge them for participating in the strike, most certainly not if it's not a protected strike. An unprotected strike is a different story. You can take disciplinary action against somebody for participating in an unprotected strike. But if a certain individual or group of individuals who you can identify engaged in very specific misconduct during the strike, make sure that you are able to cite those individuals and charge them separately on the charge sheet for those transgressions they committed. As I said before, make sure that you have your ducks in a row in terms of your evidence. Okay. If you want to take legal action against the participants in the strike that has resulted in you being financially prejudiced, such as damage to plant and material, or anything that was done that falls outside of the legal protection of a strike that has caused you financial damages, make sure that you are that you're aware of the fact that that can take quite a while to process and be on the same page as management about it. Once the strike has been concluded, debrief, have a discussion with the team, with your HR team, with us, and iron out the kinks in terms of where there was certain issues and certain mistakes that were possibly made during the strike. And lastly, review your arrangements while everybody is calm. So if, for instance, you do not have a recognition agreement and there is a union in the workplace and everything is very sideways, a recognition agreement under those sort of circumstances can create parameters that would make such a unfortunate situation, which is a lot easier to manage and control. Okay, I'm now going to move over to my last slide. Five things you need to be careful about in terms of strikes, what you need to be conscious of and guard against. Okay, now a strike can happen within can happen as a result of a matter being referred to the CCMA and a commissioner issuing a strike certificate. However, it may also occur if the referral to the CCMA was 30 days had lapsed. So simply because there is no certificate does not necessarily mean that the strike isn't protected. What has to have happened is that a 30-day period must have passed from the date that the referral went to the CCMA, and if it wasn't attended to in those 30 days, the employees may issue that 48 hours notice. You also need to be aware of the fact that your recognition agreement, if you have one with the union or with the workers, make specific deviations or provisions for certain steps to be taken for a strike to happen that are maybe not in line with the conciliation process, that you understand those processes and that route is followed in terms of that specific recognition agreement. Issuing an ultimatum and getting compliance in dismissing anyway. Now, as was mentioned by Willem earlier on, once you have issued an ultimatum, okay, that doesn't mean that as soon as they return to work, you can take disciplinary action and dismiss everybody. There has to be a certain measure of reasonableness in terms of making sure that the employees understand the legal ramifications of what a strike constitutes, and then following due process. Now, if, for example, your employees go on a strike on a Monday and it's an unprotected strike and you issue an ultimatum, and then they do that and they return back to work in half an hour, and they do that on a Wednesday and a Thursday and a Friday. Under those circumstances, I think it's a bit different. And this is where the law allows a measure of flexibility, because you can argue that that is being done deliberately to frustrate the process. However, if the employees return to work after an ultimatum, that does not mean that they are going to be dismissed as a result of it. However, there is a potential that certain disciplinary action may be taken, and obviously also derivative misconduct. Okay, citing all 400 respondents and describing none of them. So interdicting a strike is something that Willem mentioned earlier on, is something that you as an employer have at your disposal. If that occurs, you need to make sure that that if there is certain acts of violence, for instance, or intimidation happening, that you are able to identify those individuals that are doing it. You cannot simply cite the entire union or all of the workers in that interdict. Rewarding the people who came to work. I mentioned that earlier on about the bonuses, and relying on labor that print staff. So as mentioned by Willem, once the strike has ended and the employees tender their services again, you are not as an employee, you cannot use replacement labor, and you have to let your workers go back to work. So I just want to leave you off with the final quote. Every one of these is flexible before a strike starts. None of them are flexible afterwards. So look at those 5 points, just be aware of them, and just guard against them. Those are the sorts of things you need to be conscious of while the strike is happening, so that you can take the necessary remedial steps and respond appropriately. Now, just a last disclaimer: if you are facing a strike, please contact us. Okay, I understand that this discussion was done quite broadly, but it really is something that is a very subjective thing. Excuse me, it's something that is very subjective, and having professional assistance with this, it really makes a massive difference to you, as well as the manner in which these sorts of things are resolved, as well as protecting your rights. So give us a call if you are in a situation where a strike is happening, even if you suspect a strike is about to happen, give us a shout. So thank you very much for all of your time. I'm going to stop sharing my screen now, because we are now going to move over to the last section, which is questions and answers. For me to be able to see that, unfortunately, I have to stop sharing. And yeah, we'll take a couple of questions and answers. Okay. Okay, there's a question from Albert. Hello, Albert.
How's it, guys? Thanks for a very informative webinar presentation. And perhaps you have canvassed to answer this already, but just practically speaking now, let's say there's an unlawful strike, unlawful picketing outside the premises, and let's assume it's a really big company with a couple of 100 people. How does one, even if you've recorded what you think is most of the staff, let's say you don't catch everyone on your video camera, and now you want to go with mass disciplinary steps, but then people come to you, employees come to you and say, no, I wanted to work, but I was barred from accessing the premises. How does one deal with those specific examples where you don't necessarily have proof they were definitely part of a massive crowd?
Yeah, look, every case has to. So you can take collective disciplinary action against all of the employees that are participating in that unlawful strike. However, that doesn't necessarily mean that everybody will collectively be found guilty. You have to be able. That's why keeping record of it is so important, and that's where video footage is a fantastic thing. You know,
As we mentioned, every case has its own merits.
yeah.
So that also comes into play.
So collective disciplinary action can be taken. However, that doesn't mean that everybody will necessarily be found guilty. But obviously, you have to, be able to substantiate it in terms of what you can see, and that's why it's so important to keep a record of what's actually happening. If there's an employee saying that he was being barred from entering the workplace, and that gentleman or lady is seen on top of a truck, throwing things, then that would probably be a bit of a disingenuous averment. But yeah, okay, I hope that answers the question.
Yeah, I think it does. Thanks. I think the trick is to be prudent and try and film every single thing. But I hear your point. It does depend on the context.
Are there any other questions? No charge. Questions and answers are for free.
Konrad, there's a question from Talita in the chat.
In the chat, okay. Thank you very much. I unfortunately am not able to see it on the chat. Would you? Yeah,
Hey,
I'm
Konrad,
sorry,
just go to the Q&A section there.
Q&A.
Oh, there we go.
Please, can you rather have these meetings in the middle of the month instead of the end of the month? Talita? Noted. Okay. We will take note that we must have these meetings in the middle of the month as opposed to the end of the month. Are there any other questions? There's one more comment on that. Okay.
Hi, Konrad. I just want to
Yes,
ask
Albert.
you, in terms of a lot of client members will have like a conveyor belt line or, something more in the textile manufacturing where there's a team working. And let's say some individuals don't outright declare, listen, we're unhappy with anything, but you can see that it's a bit of a go slow, a bit of indolence. There's definitely a delay in production because one department affects the next. At what point, and maybe this is more academic than anything, but at what point does failure to follow or comply with your normal duties and responsibilities become or turn into an unlawful strike? Is it one and the same from the get-go? I mean, does one label that a strike if they are indolent and not doing their work at 100% capacity?
Yeah.
And you can dismiss for unlawful strike, or is it better to err on the side of caution and charge them for a breach of failure to meet reasonable targets? And I'm not saying poor work performance, I'm saying misconduct in that they've met those targets previously.
Yeah, look, if it depends, the definition of a strike is quite restrictive in terms of the four squares. So it all depends on why it's happening. If it's being done because so you as an employer have to be able to respond to a demand. So effectively, if there is a partial retardation of work, for example, then yes, it could potentially be a strike, but there has to actually also it must be done for a purpose. So if those employees are on a go slow simply because they are unhappy about the general working conditions, but you don't have a demand, then that wouldn't fall under the auspices of a strike. And I think a normal disciplinary action would be the most appropriate way of dealing with it. However, if it is in response to a specific demand, well, then the picture changes, and if they haven't followed the necessary processes, then you could potentially, I suppose, proceed with a lockout. But it is very incident specific and quite subjective, so it all depends on the reasons why they are not, why they are causing, so to speak, a retardation in the workplace. I don't know if you want to comment on that one.
On that point, no, you're absolutely right. But on that point, I would rather suggest that if the employer knows something is off, but it's not stipulated anywhere, or the employees did not come forward with anything, as the employer, I do believe there's responsibility on the employer just to speak with the employees and find what the actual issues are and why they're on a basic go slow, to see if you can resolve the matter before any action is being taken or being deemed as a tools down or a go slow or a strike or whatever the case may be. That's my 2 cents on the matter.
Thanks very much. I'm trying to find the thumbs up, but I couldn't find it. So thanks for that answer.
Okay. Any more questions? I don't see any more questions. Okay.
Konrad, sorry, I see that Vera is asking in the chat, please share the
Please.
slides to my email.
Okay, I'm going to quickly copy your email, Vera, so you can have them. Okay.
Everyone that wants the slides can just drop the emails.
Yes, send them all to Willem.
You're more than welcome to.
No, you are more than welcome to contact us if you would like to have, if you want to have access to the slides. I'm sure we'd be happy to share them. But like I said, look, this is a subject to deal with on a purely academic basis because it is something quite literal, So if you guys have any questions, please give us a call. Don't go solo on dealing with this. Let us help you with this one. Okay. Yeah. Okay. If there are no further questions, I think we can. Okay, thank you very much. I see your email address has come through. Okay, hang on. I'm going to quickly just share my screen again so that you guys can take down our email addresses because I'm not sure if the chats will be saved once we conclude the meeting. So this is mine and this is Willem's email addresses. Please just send us an email and ask us to please share the slides with you. I'm going to just hold that there for another 10 seconds. So it's kclifton@smio.co.za and wgoosen@smio.co.za. Okay. Okay. Is there one more chat? Okay, I see there's some email addresses. I'm just going to copy them. Okay. Copy email addresses. Okay. Well, everybody, it was really nice to be able to have this meeting, and I hope that you found it to be informative. And yeah, thank you very much for your time, and have a wonderful remainder of your Thursday. Okay.
Thank you, everyone.
Okay. I'm going to conclude that meeting then. Okay. Bye-bye, everybody.